was silent, but we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law,
Spinning the Law
spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, folks, so we look forward to this all the time. It's Kendall Coffey. Kendall, not only did we have the music, but Mary Walter is here beside me, too. So you got it made in the shade today.
Lucky me, lucky me. Nice to meet you, Mary.
Nice to meet you, and the pleasure's all mine.
All right, Kendall, let's get right to it, sir. And, you know, we've heard from so many people weighing in on this with the decision to trade the 5 Taliban detainees at Gitmo for Sergeant Bergdahl, and, of course, not notify Congress 30 days in advance as the law requires. Your opinion, did the president break the law?
Yeah, I mean, 70th anniversary of D-Day time. I mean, all of us recognize and appreciate our veterans, but the question isn't about our veterans or about Sergeant Bergdahl. Is did the president violate the law? And I think he did. The law is pretty clear, Steve and Mary. It says that the president, this is part of the National Defense Authorization Act, this went into effect last year, signed last year. The law says that the president must notify Congress 30 days before the transfer of detainees, prisoners, might be just as good a word, from Guantanamo. Just as clearly, he didn't. Now, there isn't a emergency exception in the law, and there isn't a special circumstances, because perhaps this was an emergency. Perhaps there were special circumstances. But, you know, I'm a lawyer. We're all supposed to follow the law. I don't believe the president did in this instance. And by the way, Senator Dianne Feinstein of California, pretty loyal supporter of the administration most of the time, she takes the same position. They have an argument, of course, that they claim that there's a broad executive power. The president, commander-in-chief, gets to do all kinds of things, even if they violate the letter of the law. They're also saying that, well, maybe there was notice given, but there was certainly no notice about these 5 detainees. So the simple question that you put to me is, did he or didn't he? And he did violate this law.
Well, now I got a more complicated one. Explain the signing statement and how that enters into it. And, you know, he wouldn't be the first president to claim this, but what's with, you know, when he signed this law, the Defense Authorization Act, I mean, I'm under the impression that there was a signing statement that makes this allowable or not?
Well, just to talk a little bit about what signing statements are, and you're exactly right. They're done by presidents of both political parties. And if a president executes a signing statement, who is in the other political party tends to criticize it. In this instance, what a signing statement means is the president sees a law, plain letter of the law. You know, some laws say speeding limit is 55. This law said 30 days before a transfer of Guantanamo prisoners, and we know how controversial and heartfelt the subject is. You got to consult with Congress. Doesn't mean that Congress gets the final say. In fact, the president's authority to determine what is the national security interest of the United States is preserved intact by the law. Just got to consult with Congress. What the president did, and as you point out, other presidents have done it, is they sign a statement or they execute a statement when they sign the law that says things like, yeah, I'm signing this law, I can read what it says, but the executive branch must have the flexibility to act swiftly in negotiations with foreign countries regarding the circumstances of detainee transfers. That's just the president's opinion. What the law is the letters that are basically put on his desk, words, the paragraphs, by the United States Congress. And if he signs that, then that's the law. He can't unilaterally modify it. He can't, on his own, create an exception for emergencies if it's not there in the statute. We're not talking about, Steve and Mary, whether this was a good idea or a bad idea, or whether there were exceptional circumstances or whether there was an emergency. The plain fact is, the plain language said you can't do it without 30 days' notice, and it doesn't matter what the president wants to write on the side of the law. The law says what it says. Presidents ought to follow the law.
Okay, just two quick questions. What about the argument that Article 2 of the Constitution gives him the power to do what he did? And the second question is what he did impeachable?
Well, great questions. And the first question is, does the United States Constitution, with the broad authority that it gives to the president as commander-in-chief, as the executive of the executive branch, does that give him the authority, in effect, to override the law? Is a part of the law unconstitutional because it would improperly reduce the president's authority? That's a great subject that could be talked about a long time. The short answer I would give is that there is certainly a presidential power that's broad. We know how important it is part of directing the affairs of our country. But also part of the constitutional structure is participation in advice and consent of legislatures. So it's very hard for me to predict where this issue would come out. Most of us watching this would think that the courts would never go near this. They would never try to have the judicial branch referee a dispute between the president and the Congress. So I don't think it wouldn't be easy to get a judicial declaration of whether the law, because it clearly means what it says, was unconstitutional, and that part of the plain language should be thrown out because it violates the executive's prerogative. I don't think you're going to get that answer from a court. I think it's going to be something that all of us can talk about for years to come. Is this impeachable? Is it a high crime or a misdemeanor? Not sure about that. I certainly wouldn't reach that conclusion. But is it a violation of the letter of the law? I think most legal observers think it is.
Fascinating conversation, fascinating topic, but we do want to squeeze a couple of more in, Mr. Coffey. How about this case where a Pennsylvania woman who poisoned her husband's lover, mistress, I should say, they charged her with chemical weapons charges and convicted her on a chemical weapons conviction for attempting to poison this mistress, actually attempting to poison the mistress, and the Supreme Court said that it was an invalid conviction. How on earth could you charge somebody with using chemical weapons? And isn't that reserved for, or talk about intent of the law, for terrorists and issues relating to terrorism?
Well, you're exactly right. And the court was unanimous, by the way, this time. Not too many unanimous decisions on strong subjects like this, but they all agreed that the conviction should be thrown out. They reached it in different ways. A number of them, conservative justices said, look, this is beyond the power of Congress. They can't be getting in and putting the federal power into what would be like, this is just an ordinary, and I don't mean to say ordinary in the sense, of course it was wrong, but this is somebody who is mad at somebody who put some kind of poison stuff on the doorknob. That is not what is intended to be addressed in the Convention on Chemical Weapons, which deals with essentially chemical warfare. So anytime all 9 members of this Supreme Court agree that a conviction was wrong, you got to figure they are absolutely right, and this was very wrong, and this was not a place for the Justice Department to be making a prosecution. We got state, we got local, we got lots of great law enforcement officers outside of the federal system, and they, by the way, enforce about 97% of the violations of the criminal laws to begin with, and this was one that should certainly stay in the 97%.
All right, so a nurse doesn't get a flu shot, and she gets fired because she didn't get a flu shot. Only could happen in our great state. Mary and I live in New Jersey, and she was working as a nurse at a community hospital, and the company began requiring employees to get the flu shot. She didn't do it, and now they say that she was unfairly denied unemployment benefits after she was fired for refusing the flu shot. I mean, how could they, I guess they said, insubordination, and that's why she didn't get unemployment benefits?
I think so, and then she takes them up on the law, which says that their policy said that you have to take the flu vaccine unless you have a medical or religious reason not to. So if you've got a religious reason not to, you don't have to take the flu vaccine. she argued successfully that because there was an exception to protect people's religious beliefs, that made it invalid because it means that you only get this exception if you have a religious belief on this issue. If you don't have a specific religious-based objections, you don't have the availability to avoid the flu shot. So according to the appellate court, that in effect violated her religious rights.
Good for her, because and good for the appellate court to rule that way. Anyway, Kendall, great talking to you, sir. As always, we'll speak to you soon, my friend.
Okay, Steve and Mary. Have a great weekend, everybody.
Thank you. It has been such a pleasure sitting here for the hour.
I heard I had to get a flu shot to be here today.
I never take a flu
true?
shot, by the way. I've had doctors tell me I don't get a flu shot. Nurses tell me I don't take it. I'm out of there. No way!
Then I'm not working with you.
Mary Walter, ladies and gentlemen.
Thank you so
Great
much.
seeing
Thank you.
See you again. All right, folks, we're coming back with Gimme 5 right here on the Steve Malls.
A code that